Hello everyone, welcome back to our channel Law Point. This is Renu Thomas. Whether you own a property or are you looking for rent, understanding the fundamental principles of leasing ensures a smooth journey. Let's unravel the simplicity of the legalities of lease under the Transfer of Property Act in India. We have with us Mrs. Praseena Elizabeth Joseph, advocate on record from the Supreme Court of India, to explain the same. So let's watch this episode.
In India, not everyone are financially capable to buy a property. So instead, they have an option of temporarily using someone else's property through a legal agreement. This legal agreement is called a lease. Here, the owner of the property allows or permit another person to use his property for a specific period without actually transferring the ownership. Here it is almost like renting, where there is a landlord-tenant relationship. However, in this case, the owner of the property, the landlord, is called the lessor, and the person who is temporarily enjoying the property is called the lessee. Sections 105 to 117 of Transfer of Property Act deals with the principles of lease. Now let us see what are the essential ingredients of a lease. Since we have seen that this is a legal agreement, so of course the parties are there, the lessor and the lessee, who must be competent to contract. That means they must be above 18 years of age and must be of sound mind. Now the second ingredient that we have seen is there is only a limited right of enjoyment to this property and there is no actual ownership. We have seen that lease is only for a temporary period. Now this temporary period can be for a shorter duration or for a longer duration or for perpetuity. However, this period need to be specifically mentioned in the lease agreement. An important aspect to be noted here in that if the lease is only for a period of 10 months or 5 months, not more than 1 year, then it is not necessary that the lease agreement need to be registered. However, if the lease agreement is for a period of 1 year or more, then it has to be compulsorily registered. Now let's see what are the circumstances in which there is termination of lease agreement or the relationship between the lessor and the lessee comes to an end. The first circumstances is the lapse of time. That means if the lease agreement is for a period of 3 years, then on the completion of the third year, the lease agreement automatically ends. Now the second circumstance is if the lease agreement mention any specific condition or happening of a certain event, then on the completion of that particular condition or happening of that event, the lease agreement ends. For example, if the lease agreement is for the construction of a road project, then on the completion of that road project, the lease agreement expires. Now the third circumstance is when there is a termination of the lessor's interest in the lease property, the lease agreement expires. For example, the lessor had only a life interest in the lease property. That means he could own the property only during his lifetime. Then on the death of that lessor, the lease agreement expires. Now the fourth circumstance is when the lessee becomes the owner of the property. Here we have seen that there is only a limited interest of enjoyment or possession of the property by the lessee. However, if the lessee becomes the owner of the property, then the lease agreement expires because now there is no lessor-lessee relationship because the lessor and the lessee merged in one person. Fifth circumstance is when the lessee vacates the lease property before the expiry of the lease period, then the right to enjoy the possession of the property of the lessee revert back to the lessor. For example, as we have seen, if the lease agreement is for a period of 3 years, then after completion of 1 year period, the lessee vacates the premises and hand over the possession of the property to the lessor, then this can be considered as express surrender of the property by the lessee to the lessor. Then in this circumstance, the lease agreement expires. Now the sixth circumstance is similar to express surrender Here, instead of expressly giving the delivery of the property to the lessor, here there is an implied surrender wherein the lessee vacate the premises without expressly surrendering it to the lessor. So, in case of implied surrender of the property by the lessee in favor of the lessor, then also the lease agreement terminates. Next circumstance is when there is a breach of the lease agreement, wherein if the lease agreement specifies that the lessee is not permitted to again sublease the property, and if the lessee again sublet the property, then there is a breach of the lease agreement, or if there is a default in payment of the rent, then that also is considered as a breach of the lease agreement, the consequence of which is where the lease agreement terminates. Another circumstance of termination of the lease is where the lessee deny the title of the landlord lessor. We have seen that the lessee has only a limited interest in the property. However, if he deny the title of the landlord or the owner of the property, then the lease terminates. It is important to note herein that in the lease agreement or there is a stipulation between the parties wherein it is stipulated that if the lessee becomes bankrupt or insolvent, then the enjoyment of the possession of the property right goes back to the lessor. Then in that case also there is a termination of the lease. Finally, if the lessor wants the property back for his own purpose or for any other reason, if the lessor gives a notice to vacate to the lessee, then on the expiry of the notice period, the lease terminates. Thank you.
Thank you for watching. Meet you in the next episode. Bye bye.